disclose an invention with the requisite language to prevail in your case. So really quick, I like to point out that the end of the inventive process is kind of the beginning of the patent process. Now obviously there's a little overlap, because you're gonna invent, and maybe you have some research and development, maybe you file a provisional application and you want to make some changes before the non-provisional. But for our purposes here today, the inventive process ends when the patenting process begins. You want to be able to disclose an enabled invention to your patent agents or practitioner, who can then write it properly for the USPTO. And by enabled, I mean somebody who is reasonably competent in your field of endeavor would be able to read the patent application and, as we say, practice the invention. They'll be able to manufacture it and build it, unless we're doing a provisional, but we'll talk about that in a second. So basically the filing date is what we secure at the beginning of the patenting process. We've written the application, the inventor has disclosed it, we file it, and now we're at the very front end of an 18-month, 2-year process of winding this thing through the inestimable bureaucracy at the United States Patent and Trademark Office. Patent pending is not determinative of patentability. You see many products on the market that say patent pending, but there's no determination of patentability by that statement. However, it can be dissuasive to competitors because it has the potential to be patented in the future, and a competitor who you deem may be infringing your invention could be written a strongly worded letter by a competent attorney like Roger, and would be dissuaded from practicing the invention until the case is settled. Does that make sense? So patent pending is dissuasive against infringers, but it is not indicative of patentability. Most investors will await disposition of the case before financing an invention. That's not always the case, because if we do a non-provisional application, well written, and we have the proper claim set, a big corporation can use their legal department to review that application and make a legally competent decision as to whether or not they believe it's patentable, and they may offer to finance the rest of the prosecution. So that's just some stuff to bear in mind. I just sort of threw that out there. I'm going to talk about the rejections, and this is why these are sort of introductory slides. It's important to understand the end of the process so that when we go into the process, we're informed as to how to best approach a strategy. Every patent is different. Every inventor has a different idea. It's a novel concept. Therefore, it requires an arrangement of novel language in order to prevail in our case. So every patent application is going to be unique, and it's going to be written particular to the inventor's disclosure. So we want to understand the injections so that we can characterize the prior art, enable our strategies for going forward, and any future amendments that we may wish to make. Come up with a good claim set to know where that line of patentable, distinct subject material is, so that we can get the claims as close to that patentable line as we can. I'm going to explain that a little bit more. And it, as I said before, it engenders competent responses to the office, to the USPTO, before we even get them. It also helps us in our search strategies. If we know how the examiners interpret language, then we know the metes and bounds of the prior art, and we can better determine whether or not we have a patentable idea. I get surprised, I should admit this, but I get surprised on a fairly frequent basis on the patents that issue. I'll have one client who I'm sure this is a patentable invention, it's brilliant, it's novel, rejected. I got a notice of allowance today for a polymeric sheet of plastic that attaches to a shower curtain. And that kind of blew my mind. I was expecting an office action. I got no office action responses. It sailed through. It issued in less than a year. I can't believe it. It blew my mind. But that happens. That happens. And it all comes down to the language and the way the examiners are going to search the prior art. So claim dependency, I'm going to get into this a little bit more too. Basically, a broad claim obviously is more commercially viable. It means it covers more intellectual property. It's broader. A narrow claim has more limitations in and is less commercially viable. So we want to get the broadest claims we can while including a patentable limitation. So that's kind of the dance of death that we as language people try to do for our clients. So let's talk about the anatomy of a claim. So a claim must by definition be a single sentence, and it must have at least these two elements in. So I guess I'll come back to that. It needs to have a preamble the claim body, which is the limitation sets forth this particular claim element. And then the strategy that I often find successful is a purpose clause or a conclusionary statement at the end, the wherein and the whereby. I'm going to get back to this in a second. So claims, if intellectual property is real estate, a claim is the boundary. So when I set forth my claims, I'm going to claim a writing implement, like this pen. And I'm going to set forth in a set of unique sentences the metes and bounds of this pen. And the first claim I'm going to write, I'm going to try to make as broad as possible to cover multiple embodiments of that pen. You know, is it a ballpoint pen? Is it a quill? Is it a stylus? I want to get as much as I can for a writing implement, right? So that would be the first claim. And I'm going to explain the dependency chains in just a minute. So, as I said, claims essentially define the metes and bounds of an idea. But they're not read in a vacuum. The claims, being the most important part of any patent application, are informed by the specification. The examiner, under the law, must interpret the claims by the specification as a whole. And the specification is essentially the whole application. It includes drawings, it includes the summary, background, field of invention, brief description of the drawings, and the detailed description, and even the abstract. The abstract can come into play. You never know. So the plain meaning of words is the meaning that must be taken by the examiner, unless it's contradictory to the specification. So a patent applicant can be his own lexicographer. That means he can invent his own language. So I can use any term I want. I could say, I hereby claim a gizmo, as long as I define what I mean by a gizmo in the summary. And I find this, especially for software patents, to be quite powerful, because I can define sort of abstract ideas and then delimit them in the summary. That enables me to amend the summary and maintain the claim. Does that make sense? Because I'm using a compound term that is informed by disclosure in the summary. And I found that to be quite powerful. Rejections of claims is specifically done under 112. This used to be second paragraph, but the AIA has confused me by changing all this stuff. I used to like the second paragraph and the sixth paragraph, but now it's much more sensible. It's 112B. Claims can be rejected for indefiniteness, and this means that they don't really enable the invention. It doesn't make sense. And they can reject the specification when the claims are not enabled by it. So having sort of abstruse, obscure claim terminology, they can reject under this 112. I'm going to get to the other rejections over the prior art in a minute. This is just for the bad use of language, if you will.
Can you might
Yes.
give an example of like indefinite and non-indefinite?
I'm about to do that.
Okay.
On my next slide here. So this is basically, you know, this is kind of I just wrote this the other night. This is for a pen, right? A writing implement. The claim is, this is what we would call an independent claim, meaning that it stands by itself. It starts with the indefinite article a or an. So an inscribing implement, this is called the preamble, comprising, including, having, and there's some other transitional terms that are peculiar to the patent arts. And then we go through each of these claim elements, each one adding a limitation to what that writing implement is. In this case, it has an elongate body, right? It needs an elongate body because I've got to hold it. I need to be able to wield it when I'm inscribing. So that's a necessary feature of my invention. It doesn't say how long it is, it's just elongate. It needs to have a nib member, not just a nib, but a nib member, because that is where I write from. That's the contact point. It needs to have some sort of cavity in which an ink storage vessel is positional in order for the ink to be routed through the nib. And that's where this wherein and whereby clause comes in. So I'm not going to get into the form of that too much, aside from saying that this is really the patentable subject material right here. Preambles sometimes can be taken to be limiting, depending on the case itself, on the particular invention. And the wherein, whereby clauses also can be limiting language. So we can win from a limitation that's inherent in here. And I've put one in to give you an example of definiteness while not explicitly claiming it. So for example, it says wherein ink is deliverable from storage within the elongate cavity thence conveyable through the nib member, whereby inscription upon an underlying surface caused to contact said nib member is effective. So the inherent disclosure in here, which I believe would be a patentably limiting feature of this pen, is that the nib member has some means of conveying the ink there through. So it has either an aperture, or in the case of a felt tip pen, it has some sort of capillary action that is affecting the delivery of the ink. And I would argue this, and I would argue that wherein clause in the summary, where I would have enabled it by saying what I just said. Does that make sense? So this, you can see, would cover a quill, it would cover a pen, it would cover a ballpoint pen, potentially a felt tip pen, but it wouldn't cover a stylus because of this ink storage vessel and this cavity. Correct? Does that make sense? Mm-hmm. So what is definite about this claim is these nominatives, I like to call them, so long as they are enabled and appropriately disclosed in the preferred embodiment in the detailed description or elsewhere in the patent application. So now what I would do next is I would add what we call a dependent claim. So having defined that the ink storage vessel and this cavity is what makes this patentable over the stylus. The stylus already exists. This is the very first pen. Maybe it's a quill, who knows. So the next one I would do is what we call a dependent claim. Now this claim will necessarily include all of the disclosure of the first claim, and it would add at least one additional limitation. So in this example, let's say I'm going to try to get the ballpoint pen as well, which I already have, but I'm going to add in another limitation. I'm going to say the inscribing implement of claim 1, further comprising a spring member disposed interior to the elongate cavity between the ink storage vessel and the elongate body second end. So I've just added in a spring, right? You follow what I'm saying? So I've got the pen, I've got this, and now I'm going to have 2, this job further comprising a spring. So now I've got the spring. And maybe for claim 3, I say with a depressible button disposed at the second end, right? So what am I doing? I'm adding limitations in, right, into this dependency chain. So this one, if I win this claim, I necessarily win all of these that depend from it, but I don't win these 2. So what I've done is I've defined what I hope to be the broadest stake of my intellectual property that I can muster, and I've added in these claims. So if the patent office comes back and says, you know what, this pen has already been done, man. We've got quills, we've got fountain pens, but this spring member is a novel feature. Then I can amend the application to merge these 2 together, and this would become claim 1, claim 2, claim 3. Does that make sense? So I'm trying to define where that boundary of patentable, distinct subject material begins. And I want to get as close to it as I can, which is why getting an office action response from the office is not always a bad thing. It shows that we're encroaching a little bit too close to somebody else's invention. And so we would amend the claims appropriately. So then, you know, these are 2 different dependency chains. We don't have to get into that too much. Then we might throw in another independent claim, which would have all of these limitations perhaps, or one of these species in. And then I typically end, my strategy is to end with what I like to call the picture claim, which is like a giant independent claim that has every limitation and you can possibly imagine. And it's like at least a page long. It's this giant long sentence that is just probably a nightmare to read. But this should be patentable. We don't really want to win this one. We want to win somewhere up here. But this is a common strategy that you'll see when you read patent applications and patents. So I put this in like this, because sometimes you're going to have 2 embodiments. Now it is required by 112, used to be first paragraph, that you disclose the preferred embodiment in the application. So in this case, my preferred embodiment might be the ballpoint pen. But I'm also going for the fountain pen, I'm also going for the quill, you know, I'm going for these other pens too. But my preferred embodiment is the clickable ballpoint pen. So as long as I've disclosed that as the preferred embodiment, I'm okay. I don't have to say which embodiment is my preferred embodiment. The law doesn't require that, but it does require that it is disclosed. So in this case, maybe this dependency chain goes onto the ballpoint pen, and maybe this one is the fountain pen. Maybe this one adds in a ink bladder, depending from the storage vessel, and this one is the clickable, the pressable button. So the danger of this, though, if these embodiments are patentably distinct, and Roger asked me to bring this up, is it could render what we call a divisional filing. So the patent office may ask us to restrict, they'll issue a restriction to restrict our application to one of these two inventions and file a divisional application if we want to win this one. So far, so good? All right, let's move on. So that's basically the format of a claim. There are these various thresholds that we need to meet. This is obviously the claims are interpreted in light of the specification, so we have to enable it. Teaches the prior art. The level of ordinary skill in the art is the manner by which the claims are going to be interpreted. So if you're in a highly technical field, like the computing arts, the level of skill in the art is quite high. And I don't necessarily need to define, what a server is. I can just say server, because anyone of ordinary skill in the art would know what that is. So that's what this is, and this comes into play quite a bit. And then there's other things to worry about, because we have a very peculiar use of language that for 300 years has been defined in cases. So for example, terms of degree, just as one example, all have peculiar meanings to patent law. Just like the word comprising and including might be synonyms to the average layperson, but to a patent agent, comprising is a broader transitional than including, which in turn is broader than having and consisting of, and consisting essentially of, and all these things have case history that we argue as to the broadness of the limitations that follow that transitional term, right? So we have all these ridiculous meanings. So here's the patent prosecution overview, and this is kind of, I just wanted to throw this around because, I've worked in high volume business, unfortunately. I worked for a law firm that I was arguing an office action every single day. I was like a workhorse. I worked 18-hour weeks. I mean, like days, excuse me. It was just a nightmare. My boss died. It was a horrible situation. But it was a great crash course in patent law. And I've seen both sides of this business. I've seen the unscrupulous side, and I've seen the proper side. And what you will find out there is that there is a lot of pushes to get folks to file provisional applications because they're cheap. They're affordable, and many practitioners, and I see this all the time, I see very competent law firms do this when clients come to me with a provisional that is 2 to 3 pages long. They just cut and pasted the disclosure, filed it, billed, thank you very much. Maybe it took them 2 hours, I don't think that's right for reasons that I can get into in just a second. So I wanted to go over this just a little bit to explain the difference between a provisional versus a non-provisional and some of the pitfalls that you as inventors may face in filing a provisional application. Now, provisionals are good. They're perfectly worthy tools. Don't get me wrong. They just happen to have this public disclosure statutory bar, and they are an incomplete version of the non-provisional file. So we file the provisional under 35 U.S.C. 111b. So the drawings and specification only are required. So we don't have to set forth claims. We don't have to set forth an abstract. We're able to do a pretty loose, broad disclosure. We file it. It sits in at the patent office for 12 months, and no one looks at it. No one looks at it until somebody files the non-provisional that will claim the benefit of the provisional's filing date. And at that point, it will come into play. And then an examiner will look at the provisional to make sure that it has defined broadly enough the disclosure that we're going to subsequently claim in the non-provisional application. I don't know why this thing keeps coming up here. I have no idea what that even is. Sorry. So anyway, a provisional is essentially a temporary, incomplete version of a non-provisional. It is only applicable for utility patents. You cannot file a provisional for another provisional. You cannot claim the benefit of a provisional filing with a design application. It is just for the utility filing. And it has no implication of patentability. And the good news is that the figures can be photographs, hand-drawn things. I mean, it's great to file a whole bunch of stuff with a provisional. If you're an inventor, you've got a notebook, you can Xerox the notebook, and you can file that as part of your disclosure. And I know some people that do. I still like to write it out, personally. I still like to write the provisional like a non-provisional. I just exclude the claims, and I maybe use more conditional language to give it more scope. But I like it to be in line with what we're going to do later at the beginning, so that when we come to do the non-provisional, we can do it fast. I've already said that it's not reviewed until the non-provisional is filed. It is looked at to determine the scope to afford the priority date. The priority date is the filing date. If I'm speaking too fast, stop me, ask questions. I'm just trying to get through these slides to get into the more interesting stuff. It automatically abandons after 1 year, which means that if you don't file the non-provisional, it will automatically go abandoned and you'll lose that filing date. Now this is important because of the public disclosure statutory bar. What often happens is folks file a provisional for budgetary reasons, because it is much more affordable. They then go about publicly disclosing their invention, because they're trying to get financing. It's like, hey, I need to do the international, the PCT applications, it costs like 8 grand, you know, I want to sell this invention. As far as the patent office is concerned, even an offer to sell your invention, whether or not any information changes hands, just an offer to sell is considered public disclosure. Some people will publish a website, right, to try to get attraction from customers, investors, public disclosure. Speaking at this meeting, public disclosure. So then what happens when that expiration rolls around and you don't file that non-provisional, you can inadvertently pass the statutory bar. The statutory bar is right here. Anyone's entitled to a patent, and except if the invention was patented or described in a printed publication in this or a foreign country or in public use more than 1 year previous to filing. So this is an example timeline of a priority date, which a non-provisional application is claiming benefit. So we file March 8th, 2000, we file a provisional application for that pen, that writing implement. By March 8th of 2001, this will go abandoned. If we file any time in between here, the non-provisional under 111A, then this application, which will be examined, will be given this filing date, right? So if we let it expire and we publicly disclose on March 9th by going live with a website, by ringing up Walmart, whatever it is we want to do, March 9th of 2001, if we have not secured this filing date with this filing, we can lose rights to the patent forever. That's a very important pitfall, because there's a lot of peddling of provisional applications and stuff. So I want you guys to be clear about that.
Ben, can I ask you a question?
Absolutely,
So
Tara.
the main reason that people do a provisional is for monetary purposes?
That's not why they were devised. I would say, in my experience, the reason that most folks do provisionals is budgetary, yes, for money. But it was originally devised for competitive industries. So, you know, again, in the tech fields, in the software arts, you got Samsung versus Apple. They're rushing about the same idea. I've got enough disclosure, I think, to draw the metes and bounds of what I want to claim, but I don't have it quite coded yet. I may have changes, so I file a provisional application, secure the filing date, work for a year, and file the non-provisional, and then it's fleshed out. That's what it was devised for, but it's not used for that often.
Yeah.
I mean, it is, but I think it's, yes.
When you go to file the non-provisional application, it's just a simple process. It just takes a day. I mean, I know it takes a long time to get approved or disapproved.
Yes.
But if I say, okay, I got all my paperwork, and if I take it in today, I'm on the 333rd, you know,
Yeah.
and I still have 33 days, it'll be processed
Yeah,
today.
if it's
or
written
tomorrow.
and you filled out all the forms, power of attorney, microentity status certification, ADS, IDS, all the other annoying forms that go along with it, you can do it on the internet through the EFS system. Yeah, it'll take like maybe 20 minutes probably, I think, max to probably do it.
I might mention that the non-provisional, a lot of times, like Ben said, you're getting a preliminary disclosure on the provisional. You're getting an early placeholder, and then when you do the utility a year later, probably added and refined to the disclosure. So that's fine and that's normal, but you're only going to get your priority date on the matching items, right? New stuff is your utility.
Yes, it's a very good point.
Yeah.
Very good point.
But the provisional does stay secret always. So if you file a provisional and let it drop, and let's say you didn't hit the market, you had some other issues, it's not disclosed.
That's true.
Kept secret.
As long as you haven't publicly disclosed.
Well, yeah, because you file it, it stays secret the year, and then it's shredded.
Oh, okay.
So as
That's
long as you
completely
haven't-
different than what I understood from what you
No,
said.
what I was saying is if you publicly disclose it. So if you file
That's
and
if
then
you
you
take the
Oh,
break
I
the
see,
call,
I see.
if
Yeah,
you don't
yeah,
say
yeah.
anything,
I see, okay.
no love lost. You just lose that filing date. That's all.
Uh-huh.
Yes, Jason.
So, in that regard, if you're a group of people working on it, what's considered public disclosure? Because you're going to talk about it within your group. Is that considered public disclosure, or it has to be
It
deep
depends.
in your head?
It-
You don't talk about it.
It depends. If you have a reasonable practice of secrecy, you're in a corporate structure.
Yeah.
There's non-disclosure agreements signed. There's various levels, and there's some arguments as to that. And it's on the patent bar quite a lot. For example, they have a question, and it's a private fundraiser at a museum, and an invention is disclosed in a PowerPoint presentation for like 30 seconds. It's public disclosure.
But in terms of working as the group, so you got mechanical engineering, electrical engineering,
Yeah,
all working on
usually
the
you
same
have
project.
employee agreements and all
Exactly.
that.
And
There-
that
there's a-
considered, okay.
If you have the corporate structure.
Right, okay.
If it's
There's
just me and
another
you.
concern though that I think some inventors miss, and there are some groups in the country who get together, you know, that take random people, let's say 6 people in here, and they say, well, let's talk about each other's patents, and of course this is confidential, right? So they
Right.
help each other out. You've made a disclosure because there's no need to know, and you guys could explain that better than I can. You know, if they're completely divergent inventions,
Mm-hmm.
you've disclosed.
Right.
Right. So
You're not
there's
working
there's
on the
a
same project.
there's a fine line, it sounds like.
Yeah,
If-
well, a blurry line.
A blurry line.
Yeah.
Yeah.
So if you can show they're within the same group corporate structure, if you're outsourcing some of the work, that probably would,
Non-disclosure. Talk to
Yes.
Roger. You want a lawyer to write a nice NDA, and yeah.
then
get
that
done.
would help protect.
Yeah, that's
from being
persuasive
public.
in court that you did due diligence to maintain
The
secrecy.
thing,
Okay.
the way to look at it, does that individual have an obligation on disclosure contractually? So if I talk about my product on the 84th floor of the Sears Tower,
Mhm.
it's not necessarily a public meeting, but if I don't have people under an obligation of disclosure, that is a public disclosure.
Right. Driving a car.
Threshold is very low. You know, and that's especially when you're in the trade secret phase, where you're,
Yeah.
Well,
And why is this so important? Because your competitors will try to prove you publicly disclosed.
right?
A lot of our
That's
cases
the way
will
to,
come this. Yeah.
try to invalidate your patent.
Exactly.
Got it.
So I mean, same with the provisional. If I'm a competent legal team and I can invalidate your filing date, I will. So you want to make sure that you don't use LegalZoom to file your provisional patent application. I think that's a terrible idea.
Yeah.
No.
It's out there.
Well, there's another point too, from a marketing perspective. I mean, I'll sign non-disclosure agreements and insist that we do when I talk to a new inventor.
Mhm.
And one of the things I'll recommend to them too is if they have children at home, have them sign a non-disclosure. Now, do you have to? No. But you take a 12-year-old who's proud of their parent and what you're doing and putting together, and they go tell their buddies,
Mhm.
okay? Then you go back to corporations that'll try to, you know,
Yeah. they'll try to
say
find
you've
that out.
disclosed, well, your son disclosed, or your
Right.
daughter disclosed.
It's rough. It is rough. It's a dog-eat-dog world, unfortunately. I mean, it comes down to this too. Let's say you have you're an automotive inventor, and your invention's inside the car. No one can really see it, but you drive it on a public road. You publicly disclose your invention, arguably.
It's also, I think, a good lesson for children to learn about the importance of intellectual property. You know, it's not that they really understand totally, but it puts it at a level where they say, ooh, this is important.
Silence, right?
Mhm.
Maintain secrecy,
Mhm.
right?
Mhm.
One other thing that provisional, is just a US thing. So if you're thinking about foreign patents, the foreign patent due date is the same as the provisional expiration.
12 months after
Years,
filing,
so, for that provisional to be priority in a foreign country, it needs at least one claim in it to be called patent application. So that's not a requirement in US law, but we always just throw at least one claim
I do
in
see.
case someone wants to go foreign.
And that claim can be as simple as, as set forth in the specification.
Yeah.
I claim a blah, 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 as set forth in. So Jeff, did you have a question?
I wanted to add on to Jason about outsourcing.
Mhm.
If at all possible, try to break up your invention to multiple outsources. That
Mhm.
way, you don't have one company who has all of your proprietary information. They have a piece of it, and they don't understand what the bigger product is that it belongs to. So that way they can't really run them with your idea. If
Cool.
they,
In fact, Tesla did that between the world powers back in the 1930s. He gave half of his wireless energy transmission to the U.S. government and half to the Russians.
Oh my.
They're still under Secrecy Act, so I don't know what that was.
Wow.
I'll tell you what, there's a thing up in Alaska that's operating with it. I'll tell you that right now. Anyway, anything else, or should we move along? We're good? Okay. So the non-provisional, we kind of talked about this. We probably don't need a... This is the one that really goes through. You know, it goes to the prelim. It gets filed. It goes to the pre-exam unit. It's determined into its field of endeavor, so it's assigned a class that is being updated, as Roger pointed out. It's queued for examination. It's examined. Any office actions may be issued. Amendments, some arguments may be made back and forth to define that line of patentability, and at the end of which it either issues or it is rejected. If it's rejected, we have a couple of other options that are possible. We can do a request for continued examination and try to get it in front of a different examiner. Maybe the examiner was using impermissible hindsight. Maybe, you know, we have some good arguments. Maybe it's worth doing this RCE process. We can file a continuing application by adding new material in, continuation in part, which would split that filing date to try to get around some of the prior art. And in the end, we could maybe try to appeal. If it issues, there is an issue fee that's due at the PTO. And then, you know, these are just some of the other forms that are required. I had a client actually contact me from Mexico recently, and he'd been doing a lot of this process alone. And he had some guys in Mexico do the PCT. They filed it over here, and he did the filing himself. So he didn't know any of this stuff. He was pretty good with the application, you know, even though it was translated from Spanish. But his prosecution, his file wrapper, Roger, is like this long with all the, you know, missing parts. It was just oh man, it was a nightmare to read through it all. I still haven't finished. So that's why I threw this in here. This is your just additional forms. This is under the AIA, the microentity status, which has reduced the filing fees for individual inventors, which is kind of cool. If you reported a gross income under like 150,000, 162 bucks, and have less than 4 patents in your name. Otherwise, all the fees went up. So that was the Obama administration's way of being nice.
For patent law, patents you did while employed don't count. Okay.
Right.
So it's only patents done in your name as an individual. Plus provisionals don't count, and foreign don't count. So all that counts in the 4 is applications in your name as an individual that are utilities. But the downside is those continuations, those do count.
As separate.
Yeah, so that's another one of the 4. So if you file and then you do a continuation, that's 2 against you.
Right.
On the same invention.
What about co-inventor?
That's okay, as long as they both have a
Well,
reported gross income.
That's
How does that
cause problems, because if you've got a co-inventor that makes good money,
Well then, yeah.
they kill your discount.
Yeah,
So
yeah.
what kind of,
If one inventor makes over 150,000, let's say there's 2 or 3, or if one of the inventors has gone over the 4 application limit,
Yeah.
it kills it for everyone.
The invented entity
So
has to
that's,
have
that
that.
kind of stinks.
But
how
if
much money are we
you-
talking about here?
You mean the filing fee? It's
Well,
400.
yeah, you're talking about all these forms
Oh,
and
it's
so on.
a-
You're talking like $100 versus $1,000?
It's like $400 for the filing, examination, and search fee for a micro entity. It's $800 for a small entity, and it's $1,600 for a corporate.
Okay.
Just to get it in
And
the door.
400 from micro. But the micro, your savings go to issue fees, your savings go to maintenance fees.
Yeah, all the
So
way through.
at the end of the process, I would say you're probably going to save between 5 and 10,000.
With the maintenance
If you
fees.
stay micro.
Because maintenance fees get more and more expensive. We've been into thousands, even for the micro
Yeah.
entity. I think the issue fee is $235 right now, isn't it, for a micro entity?
Yeah, they reduced that, but the maintenance fees, especially get to the 7th and 11th year. Oh gosh, a large
Yeah.
entity, you're probably looking at 8,000.
Yeah. I looked up the other day.
And
Right.
so the micro, you're probably gonna pay 2 just for that, so it's.
But hopefully by then you're making money on the invention, otherwise why bother
Yeah.
maintaining the
And
patent?
the point is, you should be making so much money.
Right. It's a dollar.
If you do your marketing.
And,
Yeah.
and if there's a verifiable need
Yeah.
for the product, you know? Yeah.
Right. Sometimes even if you do the marketing right.
Right, it's like the
Make
pet
it.
rock, right? Do you remember the pet
You got
rock?
it.
Is that trademark, Roger?
Yeah.
The the pet rock. That's a brilliant idea right there. So this is off my website, so ignore this stuff. But basically, we've got disclosure of the invention. We want to do a prior art search. Obviously, that's important. We draft the application. You approve signing. We authorize it to file. And this is the bit we're talking about. So the provisional just goes up here, boink, and it goes around again like this. So this is the other one. So the non-provisional will go, it'll be queued for examination. And if the examiner doesn't find any prior art that's relevant to the idea disclosed, then congratulations, you get a notice of allowance, and it issues. You've got 20 years from the filing date for a utility application, utility patent, and 14 years from the issue date for a design patent. We don't really, designs, we're not going to talk about much. So, but if they do find prior art, then it's going to go into this little loop here, and we're going to issue an office action. The practitioner will argue an office action response, potentially forwarding an amendment, try to get around the prior art, argue why it's unique, change the claims if necessary, which is very bureaucratic. And then it will either drop out and be issued, or it will go again. The examiner may find new prior art, which means we still have a non-final rejection, and we may go around again, or the examiner may sustain the rejection with the same prior art, in which case we get a final rejection. We get one other shot to win against the final, and then the examiner might say no, and then we've lost the case. Yes?
Somebody else's provisional patent, is that prior art? Or is that in its own secret little lockbox and you can't see it?
If a non-provisional has been filed that claims the benefit of it, then it is a reference
Then it's prior
when it's been
art.
published, yes. But if it's just gone abandoned, as Roger said, it
Utility was never
goes.
filed, it's,
Okay.
Yeah, it's just.
Or if it's in that 1 year window and it's in the examiner's drawer, is locked up, say for something, he doesn't look at that.
Right.
Use that as prior art. So, okay, so it's whoever gets the.
Then you get into interference proceedings. Like if you had, let's say a guy filed a provisional, no one knows about the provisional. 2 weeks later, you file your non-provisional. He does claim the benefit. He wins a patent. You win a patent. There could be some problems between the two of you, and that's when all of this gets
Okay.
really
Okay.
important. They got rid of the 102E stuff. Now it's the first to file. Before it was prior inventorship, and there was a whole interference proceeding that was a bit of a nightmare that you could go through to try to prove priority to the invention.
it's pretty rare though.
Yes, that's not happened to me.
We're talking 650,000 applications filed annually.
Yeah.
Those procedures are like hundreds. So, it's so rare you don't even let it.
So let's talk about the way the claims are rejected. This is what I wanted to focus on today, because this is why we write claims and how we're going to write the claims. So claims are basically rejected under these. There's probably a few others, but these are the main ones. So under 35 U.S.C. 101 for lack of utility. What does that mean? It means it violates thermodynamics. It means you're trying to get a perpetual motion machine. It means you should never have filed the patent, and your patent practitioner is probably a scumbag, because you should have said, hold on, that's not going to work. You haven't enabled that. Under 112, for lack of enablement. The invention is just a concept. No one could reasonably reduce the invention to practice having read the patent application. It's like me saying, I patent a laser pointer. That's not enabled. I have to get into how it operates. It's got buttons on a first surface. It's got, a laser that points out the front. I've got batteries. So that would be enablement. And these are the two that we're going to be talking about the most. Under 102, which means that it is anticipated. We're going to talk about what that means. And the most common one is 103. It means that the claim presents obvious variance to anyone of ordinary skill in the art. And examiners can use infinite number of references in hypothetical combination to read over the limitations set forth in a claim. So if, this is the only rejection I like to see on any of my applications. I will admit that sometimes I get these, and yet sometimes I get these. They're usually quite easily fixed. But this should be very rare. This should be rare too, and this one should really be the only rejection that we get in an office action response. So, let's keep moving. Let's talk about the 102 rejection, anticipation. So anyone is entitled to a patent for any process, machine, manufacture, or composition of matter. Here's the public disclosure statutory bar, 102A1, and then 2. The claimed invention was basically witnessable, if you will, in another reference. Now, what is a reference? A reference is any printed material whatsoever. It could be a photograph from Popular Mechanics. It could be somebody's Facebook post. I've only ever seen a magazine used once as a reference, by the way, but nonetheless, these are references. Yeah, for the most part, it's going to be a patent, or it's going to be a patent publication. That's typically what we're going to get. But in order for a claim to be rejected under 102, each and every element set forth in that claim, so in my inscribing implement, the elongate body, the elongate cavity, the ink storage vessel, and the nib member, all of those things would have to be found in one prior art reference, either inherently or explicitly. Right? And the reference includes drawings, it includes the summary, it includes everything, but they have to be found in one reference. I'm not going to bother with some of that stuff up there.
So,
Yes, sir.
so if, for example, the wheelbarrow, if no one has ever patented wheelbarrow, because it falls under one, right? Because
Yes.
people have made it, it's public domain.
And
so
the
to speak.
examiner would show that. They would show a photograph of it, or they would, they would say, I own a wheelbarrow and I've had it for a year.
So
They
you'd
could use
have-
their own expertise.
So you'd have to have something different, a wheelbarrow that had something different and patentable.
Yes, patentable subject matter.
All right.
Some innovation, human ingenuity that is unique relative to the whole sphere of prior art. So a claim is answered. I've already said that right there. This is the precedent-setting case, or one of them. And here's another good example of anticipation. The claim is needed to anticipate if any of the structures or compositions of the scope of the claim is known in the prior art. That's the same thing that we've just talked about. I'll jump across from that one. So this is important, inherency. The idea of inherency is, like I said before, in that other claim, where I had the wherein clause, wherein the ink was deliverable through the nib member to inscribe a surface made to contact the nib member, or whatever it said. Inherently in that was the fact that there's some sort of conveyance for the ink to flow through, right? So that would be an inherent limitation that could be found in a prior art reference, if that claim is being used as a prior art reference. Does that make sense? So for example, the prior art reference doesn't need to explicitly state what it is that the examiner is rejecting it over, if that is inherent in it anyway. So for example, the rocket that enables, the flight to the moon could anticipate the rocketry of the intercontinental ballistic missile, even though the use of one was not known at the time the other one was made, but the structure is exactly the same, and therefore it could cover that limitation. Does that make sense? That's kind of an inherent. And then equivalency is the idea of, two things that are basically performing the same function without any particularity. So the difference between a screw and a nail, they're both fasteners. Or maybe we change the material. Well, that's still probably anticipated through the doctrine of equivalency. So here's my example of the nail. Shape and size is another good example of things that are equivalent and therefore can be anticipated in a single prior art reference. And it is this means the first phase. This is a legal jargon for, putting forth the rejection and the back and forth that follows. But a prima facie case of equivalency results when the element performs the function specified in the claim in exactly the same way. So is it a vent or is it a funnel? Well, if the funnel isn't really funneling, then it could be equivalent, It's not excluded by any explicit definition provided in the specification for an equivalent. So there's no language in there that says this funnel is specific to funneling, not just venting, and specifically states no venting. Then it could be an equivalent. And this is this means plus function limitation. In the old days, you read these patents from like the 19th century. I love these patents. They're really short, they're tight, they're really cool. They got like handwritten drawings. They say things like means for electrical conductance, or like antenna means, right? And the means is everything. And it wasn't until recently, right, they came up with a 112.6 paragraph, which is now 112F, that restricts the means plus function language. So if I said, laser generating means in my claim, I would have to enable what that means in the specification. And it would be limited to that. And that's what this is kind of referring to. This is the biggie. Often, if we get a 102 rejection, it would usually be directed to one broadest claim. You don't get many of them because you need to find each and every limitation in a single prior art reference. And if your practitioner's doing his job, That's not going to happen very often. So this is the biggie, and this is what is hard for searches, at least in my experience, because the examiner has the entire world of intellectual property at his disposal to find references, and can use an infinite number of them in hypothetical combination. So a patent, I'm not going to read all that, but basically it says what I'm just saying, that if the differences between the claimed invention and the prior art are such that anyone of reasonable skill in the art would have found the modification to be obvious. And how do we prove this obviousness? By showing it in arrangements of hypothetical combinations of prior art references. So obviousness is really where I think the great war of patent arguing happens. It's non-obvious because there's no necessary motivation to support combination. You know, we're going to talk about the Graham factors that came from Graham versus John Deere in 1955. This guy Graham had invented a kind of a springed wedge for a plow, and it was a shock absorber. And he made a modification to it with a second patent. And then he sued John Deere for infringement. And he won, he lost on appeal, and then I think he lost in the end at the final appeal. So maybe he lost, he won, and he lost. I think that's how it went. But out of this case came the famous Graham factors. And then this very important case, the Supreme Court settled in 2007, KSR versus Teleflex, which we'll talk about a little bit later too. So hypothetical combination of prior art reference to support a 103. It's got to be in the same field of art. There's got to be motivation, either explicit or inherent in the references to support combination. And they can use unlimited references. Those are the things to take away from that slide. So let's talk about Graham. Graham versus John Deere. The so-called Graham factors are: the examiner is supposed to determine the scope of the prior art. In other words, it's got to be within the field of endeavor. If it's outside the field of endeavor, it cannot be an obvious variation. You know, you can't be looking at, there's a great case, I'm trying to remember what it is, it might be that Vertigo versus, but anyway, it says, you know, no, it has not been shown that anybody who would be reasonably concerned with, you know, wire mesh for insect repellents would have been motivated to consult a reference to do with a mesh in an engine. And therefore, they're outside the fields of art. And that's a strong argument against obviousness. Because no, it's not obvious, because you wouldn't think to do that, because they're different sciences, if you will. We're going to ascertain the differences between the claimed invention and the prior art. Well, the examiner is. And then this is a good one too: resolve the level of ordinary skill in the pertinent art. And this is the person having ordinary skill in the art. You see this ridiculous acronym, FOETIO, whatever it is. I've got my own in here somewhere. But this again is your tech level of the field of endeavor. And then there's secondary considerations that can overcome obviousness. So perhaps all of these things apply, one or any of them, one or all of them can apply to establish obviousness. These are arguments against it. We can say, yes, but it's a long felt but unsolved need. There are a failure of others to reduce the practice who've attempted this, and I can show this and invalidate the finding of obviousness. I can show unexpected results. There's a great example on the patent bar. Every question on that damn exam is a trick question, just about. And there's one that, you know, basically the intended use of an invention is irrelevant, right? If the structure of this invention could be used for this, then that's inherent and you won't get a patent for it. Just because you're changing the use, big deal, it already exists, bad luck. So the question is, there's a pencil eraser, and a guy discovers that this pencil eraser attracts fish. So he makes fish bait out of it. And the question is it patentable for this intended use? Now everybody says no, right? But it is, because it's an unexpected result under the Graham factors, under the secondary considerations. So yes, Jason.
So, just to clarify, if you have something that, say, works on cleaning soil, you know, outside, but then you discover you can also clean water with it, then that's something you would expect. So it wouldn't be, you wouldn't be able to patent separate?
Would it be unexpected? That's the question.
I guess
that's what we would argue, right?
Okay.
Because water cleaning, you've got groundwater, you've got hydrology, infiltration rates.
Yeah.
I'm a soil scientist by training, actually. That's
Okay.
how I got into this thing, oddly enough. So I don't know. It would depend on the examiner. It would depend on how it operates. You know, maybe the science is around organic matter. It's an interaction with carbon aliphatic chains or something.
Right.
And like somehow it also, I don't know, volatilizes the oxygen from H2O.
So it depends how different the process works.
How non-obvious it is. For
Non-obvious.
one of ordinary skill in the art.
Gotcha.
Right? So if I'm a soil scientist, to me it might be obvious because I understand the chemistry, say. Right? And am I a person of ordinary skill in the art? Depends on the disclosure. How complex is it, right? So exactly, it's a good question, and it's very blurry. What we have here is individuals, subjective interpretations, right? Everybody's motivated for their understanding. The word patent means to manifest, right? By letters patent, by letters made manifest, I disclose my invention. Not for the reward, for my novel discovery, but to publicly disclose for the benefit of humanity, for which the government provides me a temporary monopoly as an incentive, right? So we've got all these competing wills, and it's all settled out in the courts. That's where all this stuff happens, which is interesting. It's the judiciary branch of our wonderful government. And this is a total aside, but I get excited about this. Patent law is actually in the Constitution. It's in Section 8, under the enumerated powers of the federal government, is to provide intellectual property boundaries and laws. And Jefferson was the guy who had it put in there. That's pretty cool. So anyway, sorry, off topic.
Right,
But yes?
Secondary, these things, when you get your obviousness rejection, it may be 2 years after you file. So to develop your secondary considerations, you need your product to the market. So this points to importance. As soon as you're filed, getting out of the market, learning commercial success.
Yeah, especially
And
that
there's
one.
another one up there. If you're getting infringed or the idea is getting knocked off or stolen, this is a positive thing because it validates the value of your technology. But warning, when you present the examiner with secondary considerations, they'll almost automatically go,
You gotta file affidavits.
what you have to do, let's say on the commercial success, we take a survey of the buyers of our product. We say, why are you buying our product over others? They say, oh, it's because of feature B. So we have to go back and show feature B is in the claim. The secondary consideration has to link back to what is claimed in the application to so I have to show that.
It's a great point. I mean, this is, is persuasive to overcome an otherwise sustained rejection. So there is a great incentive to reduce the
So
practice
it's
as quick as
been,
you can. I would agree with that 100%.
It can be tricky because you can have good commercial success and we can't show that, right?
We can show
People are
money
just buying them
sometimes.
because you're got great advertising, but not because of, it's hard to get a feel for, are my customers buying because of this claimed feature?
Because of the inventive
It's a
step,
little tricky.
right?
Yeah.
Very good point. So determining the scope of the prior, I'm probably going to rush through some of these pretty quick, just because I don't want to bore you all to death. So, we've got to get the examiner is required to give the broadest reasonable interpretation of claims consistent with the specification. I find examiners like to use way broader definitions or interpretations to support their rejections, and then much narrower interpretations to support their rejections. So I like arguing the case history of what defines the broadest reasonable interpretation sometimes. It's got to be in the field of endeavor. We've already talked about that, which means it's reasonably pertinent to the particular problem of which the applicant was concerned. And I may actually have, in order for the reference to be proper for use in an obvious rejection, under 1 of 3, the reference must be an analogous art to the claimed invention. That was 2004 in re vigio. So, again, if you're doing something, this is kind of where the intended use can be argued, but it's not a strong argument, but it does work sometimes. And we've already talked about inherency and equivalency, but not as it pertains to obviousness rejections, but it does. So it could be an inherent feature that becomes obvious. And the same with the doctrine of equivalency. This is when we're going to get into KSR versus Telefax in a minute. One of the things that they defined, the Supreme Court defined, was selecting from a finite number of possibilities to determine a predictable outcome. So using a screw, a pin, a nail, these are finite possibilities to affect the predicted outcome, and they're all obvious variations of each other inherently. Does that make sense? And that can be applied to a lot of other stuff. We've already talked about the claim language must be interpreted considering the invention and the prior art as a whole. So this is a very important case that I use quite frequently, because if there is any teaching, and we use the word teaching as disclosure, if there's any teaching in the prior art that teaches away from the invention, then it cannot be obvious. If you can get the examiner to admit, either inherently or explicitly, that the reference teaches away, then it is not obvious, because it is contradictory to what it is we're trying to do. So for example, let's say I have a heater, and I'm using, I don't know, a reverse refrigeration process perhaps. This is probably not a very good example, come to think of it, but it is directed specifically to heating, and my invention is to cooling, but they're using a similar process, but the one deliberately has a part of the refrigeration cycle, let's say, that is deliberately directed against cooling. Then it teaches away from the reference. So it cannot be supported in combination, which is kind of cool. An examiner, they like to do this too, but they're not allowed to distill an invention to a general gist or thrust. I find that we call this impermissible hindsight, when they're basically looking back and reassembling piecemeal the invention from whatever prior art they can find. And they'll grab things from all over the place to try to do this, like maybe from the bathroom arts to the airplane arts, you know, and just say, well, the thrust of your invention or your inventive step is, you know, to create buoyancy. And therefore the wing of a plane, under Bernoulli's principle, being buoyant in a gas is the same field of endeavor. And it's like, no, it isn't, because, you know. So that's also important arguing stuff. Resolving the level of skill in the art, here's just some ways that we do this. The rapidity with which innovations are made is not always indicative of it. You think of the technical fields. I mean, they're very quickly changing. Software is very complex. More and more people are filing patent applications to protect software instead of the preferred copy route, because patents are better if you can win. It's not easy to do. And, you know, educational level of active workers in the field, that's a good one. So this comes into play, I think, rarely in my experience, but I imagine in some of the high-tech fields it probably comes in quite often. A person of ordinary skill in the arts is also a person of ordinary creativity, not an automaton. That's an important one. This is the Supreme Court said all of these statements. In many cases, a person of ordinary skill will be able to fit the teachings of multiple patents together like pieces of a puzzle. That's totally what the examiners like to do, and they love the fact that the Supreme Court said this. Made our job much harder. Includes inferences and creative steps that a person of ordinary skill in the art would employ. In other words, the examiner is able to imagine themselves as a reasonably competent person in that field of endeavor at the time the invention was made, even though they're now in the future, and imagine what they might invent from the standard of the prior art. Yes, and it gets tricky. I mean, that's why the 103 is a problem. I think it is the major tool sustaining rejections, and it means that any search that a competent practitioner performs can never be guaranteed, because a lot's going to fall out. But it's also why losing a case is not always a bad thing, because of that information that does fall out gives us strategy for future filings and gives us information as to how we can practice our invention. Because some of these references will have already expired, and now we have an argument that we can practice without infringement, because we have a limitation covered in this one reference which is expired. So we can practice, we just can't restrict others. So it's you know, there's many things that happen in this process. Yeah, obvious person can run their own expertise. That's kind of annoying, but they basically have to supply good information to support their own expertise, and they usually look at another reference. And here's the example reference. If we ask, if the examiner makes an official statement of his own expertise, the agent needs to ask for a reference supporting it, and then it will prompt him to either withdraw that statement or find a reference that supports his argument. So here's KSR versus Teleflex, and this is a very important case, 2007. These guys, let's see, what exactly happened here. I think I put this in my notes. Right, it all came down to an adjustable vehicle control pedal connection to an electronic throttle control, and KSR argued that the combination was obvious. The district court ruled for KSR, but the Court of Appeals at the Federal Circuit reversed in January of 2005. It went all the way up to the Supreme Court, and the Supreme Court unanimously reversed the Federal Circuit's holding that the disputed claim 4 was obvious under 103. And they set forth 4 of this. So these are like the Graham factors, and these are quite important They may seem very simple. There's only, 4, 5, 6, 7 of them, but they are broadly applied. So combining prior art elements according to known methods to yield predictable results. Simple substitution of one known element for another to obtain predictable results. Use of a known technique to improve similar devices, method or product, in the same way. This is important for software. Applying a known technique for a known device, method or product, ready for improvement to yield predictable results. So what they're really doing is defining that you have to be doing something that is novel. You can't just be refining and innovating like, in a sense, the Graham factors allowed. Now it's much more strict in that there must be an inventive step, is what they call it in Europe. Some teaching, suggestion, or motivation in the prior art that would have led one of ordinary skill to model. This I use all the time against the examiners, because sometimes there isn't any suggestion, teaching, or motivation in the prior art to support the combination, and I have quite some success with that one. Known work in one field of endeavor may prompt variations of it for use in either the same field or a different one based on this. So this basically widens that, what is the relevant field of art. So all of a sudden, the airplane wing, in my buoyancy example, under this provision may become, precluding prior art. The examiner might try to argue that, and it would depend on the references as to whether we could prove them. So this is basically the end. I thought this was interesting. The percentage, from 1963 to 2012, total patent funds seem to have increased over 600%, or 6 times, from just about 900,000 to up to 600,000. And the total patent grants have only fallen 2%. They've fallen from 53 to 48%. So in 2012, nationally speaking, less than half of all applications, including foreign applications in the US, filed, issued. So best case scenario, 50-50 shot, statistically speaking.
I've applied for 4 patents, never got rejected yet, so
Excellent.
I did pretty good.
There you
So
go.
that's over 30 years.
Yeah, that's great. That's fantastic.
The last one, my patent attorney put in 2 of the claims used the manual switch, overriding a automatic switch. And I says, well, he rejected it. I says, well, just go keep trying. So you wrote a whole page of revisions.
Yeah, sure.
Just on that one switch.
Yeah, I'm sure
Cost
that
me
happens,
$1,500,
right?
but I got it.
That's it. I mean, usually it does devolve down to one thing like that.
I wore the guy out because he's in Florida. He just didn't want to spend more time, rejecting me and rejecting, you see.
Well, that's probably true. I mean, it often comes down to 1 or 2 particular structures like that. And the great thing about our side of this business versus the examiner's side is what they have to use the best prior art that's available to them. So when they issue their first rejection, unless they want to reject under new prior art because of my amendments, they're somewhat restricted in what they've already done. So I didn't write the application, back when I was working for that law firm. The application was horrible. It was maybe 6 pages long. It was for a backstrap. It was a disposable backstrap. And the idea was that you would rub like lotion on your back with this thing. And it was just like a strip, a polymeric strip. I won on an office. I was arguing the office action for my attorney, told you he died, unfortunately. I ended up doing this all the time. And it all came down to unitary handles. And the prior art that the examiner came up with was a backstrap, but the handles were detachable. So they used that, they argued it, and then I won on the definition of the word unitary, if you can believe that. I couldn't believe we won that, but there you go, we did. So it does happen. Any other questions? Yeah,
Can you go back maybe 1 or 2 slides?
Sure.
Big long one right there.
This, yeah.
Okay, so let's say that I know of a system that's in existence and it's got like 10 components to solve a problem, but it's been around for decades.
Okay.
And by applying new technology, I can replace 1 or 2 of the components in that system, right?
Okay.
Solve the same problem, but it's now less expensive and it's simpler.
Okay, I think that it depends, but I would argue, yeah, I would
Well,
argue it is.
Acceptable. If you could do the same function with fewer elements, that's an advance in the
Yeah, it's an innovation.
technology.
Mhm.
So
Even though it seems like some of those things would rule it out as obvious, so
It depends.
anybody would know. that you
It
want to
depends
take
if we
this
were
up.
doing a product by process claim versus just a method claim. And that's just a bit of minutiae here. Product by process claim, it doesn't matter what the steps are if the product is identical. A method claim, the method is very important. And I think that's what we would do probably, depending on what it is.
Yeah, you really, those things separate into structure and function. So they're primarily, outside of
So to say what you said is if the older version of what your example was patented, and let's say it's expired, and then you have a better way of doing the exact same,
Let's
basically the
say
exact same
less
function,
Using
you
new
can patent
technology.
something
It's
like
the
that.
useful improvement prong, because
Yeah.
the law reads anyone's entitled for a patent for any invention or useful improvement in any process, machine, manufacture,
Or,
or composition.
even a material change, like batteries, right?
Yeah.
I have a new material in a battery, well, it charges 1/3 faster than the old material.
Right.
Where's-
That's a structural change, a material change.
Composition of matter.
Yeah.
Right.
If the patent was still existing on the older one, can you still
It
do
doesn't
an
really
improvement?
matter.
It doesn't
because,
matter.
It's patently
if
distinct.
it's prior art, it's prior art forever.
Right.
So it would be distinct in that he has made an innovation, a useful improvement in the process,
Right.
right? By reducing the steps required, by reducing the cost required. I had a friend my mom has a friend in England who invented a new way of pressing steel, and he cut the steps down remarkably, and it was incredibly cheaper to do. And this is a little anecdote. Oddly enough, back in like the late '80s, his sales price was like down here. No one was buying. He almost went out of business. So he and his brother raised the price to like that close to the competitors.
Perceived value.
Multi-millionaires.
Yeah.
Right?
Yeah.
But that was a
I've seen that.
patentable innovation, and it was just the pressing of steel. So,
How do you determine how much of a improvement it has to be? Because like, if you
Oh.
take some, like, I know, you take an electronic
Yeah,
device, well,
very small.
you know, I've got
Very
two
small.
resistors that, now there's a new type of resistor that combines the two, you know, it seems
It
pretty
doesn't
minimal.
have to be much, and you don't really look at the size of it.
Okay.
It's just if it's different,
It's different.
and it's not, no one's one more person.
see,
Yes.
And also,
the
can
answer
you
to that
sell it?
question is a prior
Yeah.
art search.
Yeah.
I was
Right,
gonna
let's say
bring
you've done that, then we look at the
that
prior
one up,
art and we
yeah.
determine what else is out there. We can get the scope of the field of the art, we can see the variations that already exist, and we can build a strategy to determine if it is a useful improvement, right? Because it all comes down to that kind of definition.
Useful improvement.
Yeah.
Because sometimes even if you can get a patent on a useful improvement, you may not be able to go to market with it.
Yeah, I guess that's true, absolutely.
Because you would have to license the intellectual property, the prior art, to be able to do so.
So even if you're improving the prior art, you're still obligated.
If it's still active and you're utilizing, in order to do your invention,
Right.
you have to use components of that prior art product. You're gonna have to license that to even take yours to market. And if they won't do that, you're dead in the water. I mean, it doesn't matter whether you have a patent.
This is an important thing to understand, is that when you've been granted a patent, you can still be infringing someone else's invention, because
Mhm.
the standard for patentability and the standard for infringement are two completely different.
Because you've patented a use of the other patented artwork, which means that you still have to pay for it, but in that particular, well, whatever improvement that you've
It's
done.
a rare case, but it can,
Yeah.
Okay.
happen.
See, and you might only have one option there, and that is to license your intellectual property to the original company.
So,
Or,
I think that would most likely happen if you had an innovation that would be used in conjunction. So let's say I have something in the cell phone,
Yeah.
and I need the transmitter that you've already got, and I've disclosed that as part of, right, then
right.
that.
Versus creating a cell phone that's a little bit, that's practically the same but improved.
Exactly. I mean, like let's maybe I have a new antenna,
Mhm.
but the antenna must be on a particular transistor to work appropriately.
Right.
So that transistor is already patented. Now I can't really sell the antenna separate from the transistor, otherwise it's useless.
Mhm.
So all of a sudden I've got a combined product that
Gotcha.
requires his permission.
So then it leads kind of to my other question in terms of protecting patents. So if it's an improvement, so if you file a patent, you win a patent, how likely or how often is it that, well, competitor just says, well, I'm just going to make a better version and I can patent that.
They'd have to
and
go
get
through this whole
around it.
process. They'd have to have a unique inventive step.
Right.
There'd be patently distinct subject matter within a claim. So that claim would have to issue. And your prior art would act against
Yeah,
that.
you
So it'd
actually
make it
block
difficult.
Mhm.
Yeah.
So it's possible, but it's probably very difficult.
It
and a lot
is.
of work.
Absolutely it is. I mean, you know, definitely. They'd have to have a useful
It
improvement
all
innovation.
depends, right? But in general.
The reality of a patent, I mean, it's a monopoly contract between the government and the inventor.
Right.
And it does not give you a right to make the product. It's strictly exclusionary, it keeps competitors out. Now, how this can happen, if it's a regulated product, it has to be designed to meet an FDA or UL or something. The patent office doesn't check any of this, so there's a big risk. The inventor has to make it comply. Well, it could get approved and it violates FDA.
Right.
So you can't make it. You
Yeah,
guys
I see.
patent and you can't.
There's the practical side of it.
Yeah.
No, I get it.
So
Yeah.
they're, the patent office is only looking at what you claim in prior art.
It's very true. And if it's
So-
lethal, too, if it's a lethal invention, if it's an invention that kills its operator, the patent office is not liable for issuing you that patent,
Yeah, they don't.
right?
Got it. Kevorkian device or something.
Right, you know, right, exactly. Or the Darwin Award, you know.
Yeah.
A new
Yeah.
backfiring gun.
Gotcha.
Cool. Any other questions? Bill? Yeah.
You went over a lot of information here, and so, one, what's a written book that I can get, that I can go over this and really learn it?
I'd have to give you the manual of patent examining procedure. Bill.
Okay,
Okay.
that's a good answer, because
bring
that
it
leads
up
into
on.
my next one is, how do I know when to call you?
Whenever you start reading the manual of patent exam, you'll want to, because it's
I mean,
like this
I've
thick.
got some goofy idea, right?
Right.
And I prototype it up, and yeah, it basically works. I go down to the library, do a couple searches, man, I don't see anything like this. Is that when I call you and say, hey, you
Sure.
know,
Yeah.
how much is it gonna cost me to go through this? And okay, well, it's like $15,000. Oh man.
I think the
it'd take me
first thing
5
to do
years
is
get
a
that.
search, no matter what. Do the search first, and then you can figure out what to do from there. You
There
know?
must be good search methodologies that we'll learn at this other seminar, right?
Yes.
Good.
Well,
And
there's-
I recommend
Hours,
Google
though,
too.
to really
Yeah.
Yeah.
Okay, that brings up a good
And
question.
YouTube.
Another one. And this happened to me. Okay, when I was looking for the name of my company,
Yeah.
I came up with a bunch of kind of, verbs and nouns, and I put them together and kind of chopped them up and tried to come up with a name. And then I'd say, oh, that's a pretty good name. Put it into, GoDaddy. Is this name available? Oh, yes. I'm going to have to think about that for a day. Go back the next day, and that thing's taken.
Gone.
Yeah.
That's because GoDaddy
Because
has
they
an
know
automatic
you searched
vacuum
it.
cleaner.
Yeah, that may be
Yeah.
true. That may be
I've
true.
had that happen and it's
So-
happened to
so-
clients. So if
I
you,
had that happen
if
too.
you inquire, just buy the name only for the year,
Right.
hold it.
Yeah.
Cause yeah, they
Buy it
know
at the
like
time.
who's
There's no
looking.
journey for
They
it.
can
Yeah.
track it.
Yeah.
They got somebody that might be looking at it and say, oh, that's a good name, yeah, we'll just
But
grab that.
the
And
great
sell it to
thing-
them for twice the price.
The great thing about google.com/patents is you just do keywords. So you don't want to search, your invention. You might want to search maybe a process or a structure that your invention uses and just see what else is out there.
Okay.
You don't want to put in a descriptive title that defines your invention
Yeah,
completely.
I'm concerned about that.
I think it's wise, especially the NSA, right? I mean, what the hell are they doing, right?
Yeah.
I mean, they're conducting corporate espionage. It's a
Yes,
fact,
yes.
They're doing it against Germany and China, and it's a shame.
Who knows who in China is doing it to us?
Everybody, right? I mean,
Mm-hmm.
Probably the
Close
best
this down, right, I mean.
book, is, called Patent Yourself by David Pressman.
Okay.
Mhm.
And that's published by Nolo Press, and it's probably 400 pages, and it's full size. It's in its like 18th edition. It's been started in '85, so they kept it up to date, and it's very refined, good. But that's like the best book.
It's better than the manual of patent examining procedures. That's
Right.
Yeah,
Yeah,
that thing's like a
it's
slow
put
death.
into a logic that's easy to follow.
See, I don't think I want to patent something myself. I don't think that's a good idea, because I've seen a lot of people try to write software by themselves.
Yeah.
And they get into more trouble, and I mean more
It's the
money
same
getting them out of
thing.
trouble,
Yeah.
that
Yeah.
they got themselves into. So I don't want to do that, but I want to know, when do I need to call a patent professional?
Right.
You want to understand the process. You wanna
Yeah,
say,
and where in
here's,
the
here's the
process.
steps, and
Yourself.
this point you want to
Yeah.
do,
So
get with an
I
agent
like
or
to
an attorney,
think
or this point.
of a new product as a whole, a line of business, right? And in the beginning,
Sure.
like these steps and these steps and these steps. And I see each step as kind of a hurdle to jump over, and if you make it over the hurdle successfully, you go on to the next one. You
I
jump
agree.
over
Yep.
that.
Yeah.
But sooner or later, you may trip and say, oh, okay, this idea wasn't so good, but I only wasted so many man years or so many man days or so much money
Yeah.
getting to this hurdle, rather than saying, oh, I'm going to just keep going no matter what, and you get to the end and you don't have
Well, that happens.
anything.
People get entrenched, and then they don't want to quit. They're
Right,
invested. So
right.
look at it this way: it's easier to move a river at the source right? You just pick up the little puddle, point it that way, it flows down there. You don't want to start moving the river and the watershed. You got to move all the trees. It's a nightmare. So when you have the concept, when you fleshed out your idea, that is the time to get a search done. And then that might inform the strategies that you might want to take, or just give up, you know? And then you go to the next hurdle.
Right.
So I would say when the concept is fledged enough that you can articulate it.
So if I write out my thing in my notebook, and I go down and I do some searches on Google with keywords, and then I go down to the library and I spend the day down there doing their stuff, and I say, well, I can't find any prior art that looks like it's got doesn't seem to be out there.
Mm-hmm.
Then I would hire somebody like you or Roger. What's the next step? What's the next pathway to the next hurdle? Does somebody else do a better search than I did?
Well, I was going to say yeah, because you may find the references. Finding the references is easy, especially with a Google spot search. Google is actually very powerful at returning relevant results through keywords. I sometimes, when I do a class-based search, I sometimes miss something that's not in the class. You know what I mean? It's happened to me before, and I felt really bad about it. It wasn't an anticipatory reference, but it was pretty damn close, and somebody else found it. Like, we didn't go through the process, but so bear that in mind. But it's the understanding of the language in the prior art and what that means. Because
you want someone detached from it. I mean,
yeah.
the psychological problem is you're looking for something you're hoping you don't find. So that's kind of if someone isn't attached to it, they're just looking. Then when they find it, they're happy.
Yeah.
So
I've gotten to that point where
Yeah.
I'm not emotionally attached to these ideas because I've been through this enough.
okay.
It's like it's kind of like, I see it as a very Darwinian thing.
Mm.
Get an idea, you kind of make something out of clay, you throw it out there and see if it survives a little while. If it does, well, then you maybe make a mold and you make it out of plastic and throw it out there and see, oh well, it got gobbled up by something else. Okay. But if this thing just keeps going, eventually you got one you made out of gold that people are paying a ton of money for or something like that.
Yeah.
I want to see this as a stair-step thing, and each level of the stairs you're investing more time and more money, and you have criteria at the end of it,
Right.
of whether or not you're going to go to the next step. And that's
So-
the model I'm
It's
trying
called,
to put together.
in product development, that's called a stage gate process.
Okay.
And unfortunately, most inventors think of it very linear
Yeah.
because the engineering orientation of most inventors is step 1, step 2, step 3.
Right.
But really, in a stage gate process for product development, you're involving if you're looking at a big company, like I was with GE, it's not just the engineer who's inventing. You're pulling in manufacturing, you're pulling in marketing, you're pulling in accounting, because if it's not marketable, if you can't make it at the right price, why bother?
Yep.
So, you don't want to get to a point, and I've seen inventors do it, and I've seen them waste thousands and thousands of dollars by developing out a prototype, doing their own little research, and they go see a patent attorney, they get the patent filed, they get a patent, and one guy even had prototypes engineered and everything, drawings done up, 70 grand into it, comes in and says, I'm ready to go to market. I said, no, you gotta start over. Because what he had designed, what he had patented, was not marketable. No one was gonna buy it.
And that's where a provisional might be a good tool. You get
Yeah,
your filing
but
date, you got the
that's-
disclosure, you
Let-
can
let
go
me-
at it.
Let me throw something in here while you're at it.
Mm-hmm.
Even if you do cover all those bases,
Mhm.
and you do sell it to a reputable company, they gotta care about getting it in the market and selling the damn thing in the first place.
That's right.
And if they
But
have
that's
a-
about writing
if-
the licensing agreement.
No, it isn't, because you can't enforce it when you
Yeah,
go to
you
court,
can-
because you don't
give
have a
them
big enough
deadlines
bag
and
of
they can
money to
pay
argue
minimal
with them.
royalties. You can do
You can
things
pull it, right.
to force them to work, and if they don't do them, then, it
No,
expires.
you don't have a big enough bag of money to argue with.
But if the licensing agreement is written correctly, you can pull, because we know quite a few
and
inventors
did-
have pulled it,
what do you?
because they
can pull-
haven't done it. No, it's written right in the agreement.
Exhibit A.
Are you saying something like, you, the company I'm selling this to, must do your efforts to your best to sell 1 million copies of these over the next 2 years, or
Right.
else I retract your license from you
This-
and I'm going to
this-
license it to somebody else?
This license is no longer valid.
Right.
I mean, it's gone.
That would be pretty hard to
If it's
specify, wouldn't it?
exclusive, if it's
No.
exclusive, you do that, because they tied your hands out.
Right.
with the
Okay.
emails.
And they say,
Okay.
so sue me.
But it's,
Well,
you
no,
know, it
but
is,
the question would be
Gary's
the
right,
other way
there's a
around.
bargaining power problem. You know, because sometimes a company will go, this is our license agreement, you take it, right,
Mm-hmm.
if you want us, and so you gotta weigh what the potential is and the trust there, they may not be opportunity themselves to. But on the other hand, if you get the product going first, they may be getting a hold of you, then the marketing becomes better.
Right, and that's why I usually recommend, licensing is not usually the best way to go.
Not for the
If you can
first
avoid it,
thing.
avoid it.
I have a question. There is about 3,000 to 4,000 hair dryer on the market right now. Are those all patent?
Huh?
Are those patent?
Some probably, but not all.
Yeah, the patent may have expired. The original hair dryer of like 1920 expired, and now people can make hair dryers. So I bet you there are some that